What's going on, everyone? Today I want to talk to you about sexual assault and sexual harassment allegations in the workplace. Nothing strikes fear in management at a company more so than those harassment and assault allegations. Just last week, Congress, in an unusual bipartisan effort, passed what is being called the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021. It is fully expected that Biden will sign this bipartisan act into law sometime in the coming week. What this act essentially does is nullify and void previously signed arbitration agreements that were entered into by employees with their employers that prohibited sexual assault and sexual harassment allegations from being filed in a private arbitration. Essentially, employees are now going to be given the option to file those assault and harassment cases in open court, whether that's state, local, or federal level courts. This is obviously great news for employees, as previously many of these cases were covered up in hidden arbitrations that were required by the employers pursuant to agreements that employers made employees sign on the cusp of starting employment. No longer can employers enforce those agreements in the context of assault and sexual harassment. More assault and harassment allegations are going to come to the public light. This bill really brings me back to the Me Too movement that we've been in now for many years. Essentially, as those cases continue to come out into the public eye, more employees feel comfortable bringing similar cases to light. That's what this bill is put in place to do. It's to allow employees to feel empowered and know, hey, there are other employees in similar situations that have had those similar experiences with that employer. So now, because these cases have to be brought into the public light through open courts, employers can no longer sit behind the private arbitration aspects of similar cases, which prevent them from coming into the public light. This act has another great benefit. Essentially, what it's doing is it's forcing employers to update their harassment and assault policies and conduct further training on them. Because of the public nature of these cases now, there's going to be even further motivation for employers to make sure that assault and harassment cases are not occurring at their workplace. So these are certainly welcome changes that are coming to the work environment. So let's dive now into what the bill actually states. Any agreement that contains a forced arbitration of sexual assault and sexual harassment cases, that provision will be nullified as it relates to sexual assault and sexual harassment. Cases that involve sexual assault or sexual harassment that even predate Biden signing but are filed after his signing date can now be brought into court instead of arbitration. However, it's important to note, if a case is already in arbitration, it's going to stay in arbitration. This is only going to apply to the cases that are filed after Biden signs the act into law. Another important facet of this act is that it doesn't matter where the case is filed. This act is all-encompassing across the country. The next important facet of this act is the fact that sex not only applies to, gender harassment, but it also involves sexual orientation, gender identity, and gender expression, as those terms were included into the definition of sex by the Ohio Supreme Court last summer. Previously covered an episode on that decision expanding the definition of sex. We will link to it above for you to check out that episode as well. The next important aspect of this act is the fact that it also nullifies prohibitions on joint or class action cases. So prior to this act, employers could require that their employees be prohibited from bringing class action cases against them. So now employees have the freedom to collectively come together as a class action. It's important to note that although this act currently only applies to sexual assault and sexual harassment allegations, Biden has indicated a desire for future acts similar to this one that would prohibit arbitration agreements based on discrimination or wage and hour issues. Before we get into the changes that employers should be making as a result of this act, it's important to note that this act further limits other companies that have agreements with their patrons or customers to not litigate and instead arbitrate cases of sexual assault and sexual harassment. One that comes to mind are your ride share applications. When you sign up for ride share programs, it is possible that you signed an arbitration provision with that would require you to arbitrate cases involving sexual harassment or sexual assault, even if they come from that ride share driver. This act would also null and void those provisions as well. So again, it's not only applying in the context of employment and employer, but it's also applying to companies companies across the board. Based on everything we've talked about here today, the next question is, what should employers do to ensure compliance with this act? This act is going to force employees to have to not only revisit their employment agreements, policies, and handbooks to amend those arbitration agreements to ensure that sexual assault and sexual harassment are excluded. It's also going to require them to revamp and reissue and start again, not your sexual harassment and sexual assault and even discrimination trainings to ensure that all of your employees understand sexual assault, sexual harassment, discrimination will not be accepted at work, and it will be dealt with swiftly and promptly and investigated to the fullest extent. That is what the purpose of this act is. It is to further entice and require employers and companies to end the sexual assault and sexual harassment that occurs in the workplace. We once again thank you for staying tuned to this episode of Employment Law After Hours. Please don't forget to subscribe as we come to you with breaking news and other information that employers, employees, and companies need to know in this realm of employment law. Thanks, and I hope you have a great rest of your day.